We're here today to discuss life under the cybercrime law, and we have with us several experts and several people who will be as our resource persons. And as much as possible, we would like everyone to ask a question if they can. So this is think of it as a discussion online with friends about a hot topic. Our first speaker is Mr. Francis Acero.
Francis Acero here. Okay. There's
Hey,
several
Francis.
there's several things that we'd like to say about, I think, the law. Overall, I don't think there's any problem with acknowledging that crimes can happen in cyberspace. And up so far before the Supreme Court have all been they don't aim to destroy the entire law. We only seem to be focusing on specific parts of the law that are, in our opinion, quite problematic. What are these provisions? The first one that we'd like to talk about is Section 4, particularly the subsection on internet libel, or the part that incorporates the provisions of libel in those words. This provision is problematic because it seems to impose something greater than what the penalty already is for libel, and notwithstanding the fact that UN observers have come here, specialists in international law have come here and declared our provisions on libel to be contrary to human rights. Now, instead of moving in the in the direction of decriminalizing libel, we seem to have gone the other way. Now, what does the provision say? Section 4, the lawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code as amended, committed through a computer system or any other similar means which may be devised in the future. It's for libel. And then, Section 8 of the Code, there's a provision here that says there's a provision here that says that these crimes are can be punished. Our prosecution under this law is going to be separate from prosecution under the Revised Penal Code and special laws. What does that mean? That means if you do commit libel, as defined on the internet, you're vulnerable to prosecution for libel under the Cybercrime Law and the Revised Penal Code. So you get hit twice. And that in itself strikes a blow against free speech. It does not make a distinction between free speech that can be made as a political statement or to bring our public officials to account using the power of the Fourth Estate. That's not there. Because this is not in the Revised Penal Code, the intent of the person making such speech isn't considered when prosecuting under this law. So you may theoretically going after a public official, calling him to account, and they may consider it internet libel. That in and of itself is already passage of a law that attacks the freedom of the people to seek redress from government. What else is problematic here? In the enforcement provision of this law, Section 12, Paragraph 2, allows the government to collect traffic data from a computer that law enforcement authorities have recognized are identified with due cause. The problem here is, first of all, it's just due cause. Due cause is a very low standard by which government can look at your stuff. Due cause can be anything. Due cause can be, I feel like you're doing something wrong, and that's due cause already. The other thing that's wrong here is that it gives that power to the executive branch of government, which is Secretary of Justice, by extension the President, without need of a court order. In other areas of law where the government is allowed to intrude into your own personal space, we require court orders. In fact, part of the Constitution does guarantee that you're not violated in your person without due process. Government cannot search or seize your property without a court order. When you look at traffic data that way as part of your property, because it's where you go, it's part of who you are, then it becomes problematic. What if you are disseminating legitimate data? If, say, you're using a torrent to, say, deliver a political manifesto, and if this torrent catches on and gets spread throughout the world, government will look at your traffic data and say, oh, he's got a file being hosted in his computer that's now being seeded all over the world. There must be something funny going on here. So we'll look at him more closely and who he's sending that file to. Number one. Number two, they'll say, oh, we have prima facie evidence. Prima facie means on its face or obvious to the eye that he's doing something wrong. Therefore, I'll issue a takedown order, which is found under Section 19 of the Act. That's the third item that's problematic with this law. Section 19 does provide for the Secretary of Justice to, on her say-so, basically, to shut down any access to any site by any person within the Philippines. This creates a wall that anyone in the Philippines will not be able to access that content on her say-so. Now, for some of us, this may be hard to understand why it's dangerous because the trust ratings in the Secretary of Justice are high. The Secretary of Justice now will not be the Secretary of Justice forever. Let's say that some other person comes into office who's not as trustworthy or does not carry the same public trust. At that time, that person may abuse the power to search or to issue that takedown order and look at your data traffic and identify who you're talking to, and essentially, because they know what you're looking at or what you're distributing from the takedown order, who you're talking and what you're talking about. That is an unacceptable invasion of privacy. For me personally, also, the cybersex provision could have been drafted a lot better. For me, as a person on the net, and I see the word cybersex, it has a different connotation to me than what it does to law enforcement here. I think cybersex as the crime was an invention of some policeman trying to justify his raid on some place. While it's laudable, the aim of that provision is laudable to stop the exploitation of women, it makes no distinction between indecent and obscene speech. Indecent speech is protected under our Constitution. Obscene speech is not. I have some friends who say that they're involved in long-distance relationships, and sometimes intimate talk between couples is all that they have to go on. And they are in fear now that such intimate talk between them is going to be compromised because of this law. And I can't tell him with a straight face that he will not get into trouble.